Hello, I'm Eric Vernon.
And I'm Kevin Baldwin.
And together we are Baldwin and Vernon LLC in Independence, Missouri. Today I want to talk a little bit about grand juries. I brought Kevin along because Kevin used to be a prosecutor. Boo, but it's helpful often to have Kevin around with his prosecutorial ways. So in the state of Missouri, there's two different ways that charges can be filed. One way is a prosecutor can file a criminal charge with a complaint, and if he does that, then he has to have a preliminary hearing to get a judge to find probable cause before you have to stand trial. The other way is to go to a grand jury.
When you go to a grand jury, what is happening in that situation is a prosecutor is actually presenting evidence to a grand jury. Now, a grand jury is not like a regular trial jury. In a trial jury, if you were in a jury trial, normally you get the prosecution and you get the defense, and both sides get to present evidence. A grand jury is different. A grand jury is usually what's called a sitting jury, and what they do is they take a cross-section of the community, they'll grab individuals, 12, 15, sometimes even more, and they will meet once a week or once every 2 weeks or as needed. And when they're called in, at that time, the prosecutor gets to present evidence to them and ask them to issue an information or complaint charging the person with a crime. Now, if there is insufficient evidence or the jury doesn't believe they should be charged, they will issue what is called no true bill. In that situation, the grand jury will come out and say, we don't believe there is sufficient evidence to warrant a criminal complaint being charged against this individual at this time.
Now, another thing about grand juries is if you're subject to an investigation and going to a grand jury, when the grand jury is meeting, you're still a suspect.
That's
right?
correct.
You haven't been charged yet. And you have the right with a grand jury to plead the fifth, to not testify. There's no requirement that a suspect, a citizen who's being investigated for potentially having committed a crime, there's no requirement that they go cooperate with the grand jury. Kevin, can a suspect cooperate with the grand jury?
They actually can. In certain situations, a suspect is allowed to present evidence, possibly. It might be a situation where if they wish to testify before the grand jury, they usually have a lawyer do so. And I will tell you right now, anybody that appears in front of a grand jury without a lawyer is making a mistake. Because a lot of times you don't know what's important. You don't know what you're saying or how that plays into the law or the potential violation of the law. You know how they say ignorance of the law is no excuse? It's true. Ignorance of the law is no excuse. In those situations, you're better served with a lawyer. Now, when you're called before the grand jury, they can ask you questions and you can actually refer to your lawyer and he can actually help you answer those questions. There might be times when they'll say, look, he will testify or she will testify about these things, but not about these things. Or what they're doing is asserting the Fifth Amendment right, and that is their right not to testify against themselves. In that situation, the lawyer there is to preserve the fact that they have asserted that right.
Now, a lot of times the lawyer doesn't actually get to go into the grand jury with the suspect. But, and that's why it's important to have a lawyer to sit there with you before you go in and talk to you at breaks. Individuals can go and testify if the individual runs into a situation where they're not sure whether they should continue testifying or they're not really sure how to answer a question. They're allowed to take a break and step out and consult with the lawyer. The lawyer just typically doesn't go into the actual hearing with them. Kevin, do all 12 people in the grand jury have to agree to a true bill?
No, simple majority.
Simple majority. And one of the reasons I wanted to ask you about the grand jury is it seems like sometimes there may be different reasons why a prosecutor would go to a grand jury as opposed to just filing a complaint.
Absolutely. Well, sometimes you even go to a grand jury after you filed a complaint, because what happens is if I filed a complaint, the defense gets their preliminary hearing. Well, maybe I don't want to show all my evidence, or maybe I don't want to have the victim, who might be a child or a battered woman, I don't want to have them appear in court and give testimony and be subject to cross-examination to create a record. In those situations, I would take a case to the grand jury to avoid that issue. That way, if I go and get the grand jury indictment, then I don't have to worry about calling them in to testify before the court. Now, there's that reason that it's done. Also, sometimes it's done for secrecy, meaning the target of the investigation may have no idea that they're being investigated at all. That's more common in sex trafficking cases. That's common in large-scale drug conspiracy cases, where not everybody knows the fact that the investigation is occurring or how much information they have.
You know, and that's a very good point, the secrecy thing. A lot of people don't really realize or understand, but the grand jury proceedings are very secret. They're kept very secret. The jurors are sworn to all kinds of confidentiality. And one of the things that means in the federal cases, all of the discovery, all the police reports, all the FBI reports, all the documents they subpoena from banks or wherever, all that evidence that goes before the grand jury is also secret and covered by the same confidentiality. So sometimes it's hard for people to understand, but when we get grand jury material in discovery, we're not allowed to disseminate it. We're not allowed to just give it to our clients to walk out the door of our office with. What about this, Kevin? Did you ever think a prosecutor might take a case to a grand jury because the prosecutor can't decide whether or not there's probable cause there, and they want to have the benefit of the people?
Certainly, a lot of times it's like a focus group. If you don't think your evidence is strong enough, I might consider that a crime has been committed, but I don't know if it's strong enough. And if I want to overcome what I consider my personal beliefs or bias, I want to take that to a grand jury. And I want to put it in front of that grand jury, just the facts, and ask the grand jury, is there enough here to make a violation of the law? Now, there's times when I actually took a case to the grand jury before, and one of the reasons we went with this because it was a self-defense claim, which I think you're going to be talking about later, where a gentleman came to another man's house with a gun, threatening him and his family. And the man on the inside of the house felt an absolute need to respond, and to respond with force that took the other man's life. Now, this is before the Castle Doctrine here in Missouri, and I think Eric is going to talk more about that later. But in that situation, because we didn't have clear defenses under the law, I wanted to see what would a grand jury think. And in that situation, they returned no true bill. They refused to indict. They thought that what that gentleman did to protect himself and his family was reasonable. And I didn't have a problem with that. As a prosecutor, that was perfectly fine.
So, if you get a call from a law enforcement officer or a lawyer somewhere saying you need to go talk to a grand jury, call Baldwin and Vernon.
Or call some lawyer. I'll tell you right now, folks, if anyone ever named detective ever calls you and wants to discuss matters with you, or two agents or two detectives come to visit you at home, if two detectives come, it's not an interview, it's an interrogation. Okay? And they always bring one along to be the witness. In those situations, protect yourself. We've all heard about the innocent people who got put into prison when they didn't do it. And it takes years for them to find out that they didn't do it, the evidence wasn't sufficient, or they had the wrong guy. Now, most of the times, those people thought, I'm innocent. I can do this myself. All I got to do is tell the truth. The truth will set me free. Not always. You need someone there to make sure that the system is working correctly. And that's what lawyers are for. This is Kevin Baldwin.
This is Eric Vernon.
From Baldwin and Vernon. Thank you.